Professor Ahmed also examines challenges facing the Muslim communities post 9/11. She holds her law degree from the University of California at Berkeley also, and an MS in Population and International Health from the Harvard School of Public Health, and her bachelor's degree from Emory. Prior to joining Northeastern, she was a research associate at the Harvard School of Public Health on International Health and Human Rights. She came to that position after a Women's Law and Public Policy Fellowship with the International Community of Women Living with HIV/AIDS, the ICW. At ICW, Professor Ahmed engaged in numerous human rights projects pertaining to law and health. She's worked on legal issues in a variety of country contexts, including South Africa, Namibia, and India, the US, and the Caribbean. She has served as an expert member of the Technical Advisory Group on HIV and the law convened by the United Nations Development Program, and as an expert for the American Bar Association. She's on the board of the Center for Health and Gender Equality, Change, and the Sexual Information and Educational Council of the United States. She's been a peer referee for numerous publications, including The Lancet, the Bulletin of the WHO, Global Public Health, and I could go on, but it's a long and very prestigious list. And she has received grants from the Ford Foundation and Northeastern University's Program on Health Policy and Law. And it's really a thrill and a privilege to have both Rebecca and Aziza with us tonight. So, as I said, I'm going to give just a little bit of background before they go into their talks and just a little bit of context here. So, first, maybe an explanation as to why we thought this class was an important one to include in a semester on health policy. And I will say that one reason is because reproductive health is health care, and it's widely used health care. 99% of women ages 15 to 45 who have ever had sexual intercourse have used at least one contraceptive method. 62% of all women of reproductive age currently use a contraceptive method. And I think it's interesting to note that the figures are pretty much the same across various religious groups, okay? Contraceptives are used very widely, and they're used not only as birth control, but they're also often used for other forms of health. Family planning, in addition, has well-documented health benefits for mothers and newborns, right? So if women cannot, if pregnancies are not spaced appropriately, there are health risks to women and newborn. And I think this one is interesting, and by the way, all this data comes from the Guttmacher Institute, which is really sort of the place where all these kind of facts and figures. Every dollar spent on helping women avoid unwanted pregnancies saves $5.68 in Medicaid costs. We've talked a lot about healthcare costs across this semester. Well, reproductive health care is one way of getting at healthcare costs. And 9 out of 10 employer-provided insurance plans cover the cost of contraceptive care. Nearly half of all pregnancies in the United States are unintended, right? So although there's widespread use of contraception, it is often not used consistently or appropriately. About 4 in 10 pregnancies in the U.S. are terminated by abortion. We often talk about abortion as if it's sort of this side thing, you know, it's off there in the side, but actually it's in the mainstream. It is one of the most common medical procedures in the U.S. 1 in 10 women have an abortion by age 20. 3 in 10, 30% of all women will have an abortion by age 45. This is a very common medical procedure. I think it's hard to think of many other procedures where 30% of the population, right, or surgical interventions that 30% of the population have had. 85% of abortions occur in the first 12 weeks of pregnancy. Since 1976, when Congress enacted the so-called Hyde Amendment, which keeps being reenacted, enacted each year. It's actually a rider. Congress has barred federal support for abortion. I should have said federal financial support for abortion, except in cases of rape, incest, or endangerment of the life of the woman. And by the way, over the years, those exceptions have been redefined in various different ways. So the federal government and the Medicaid program, at least in terms of federal money, does not support most abortions. A few states do cover them in their own Medicaid programs with state-only dollars. Most private insurance plans cover abortion services to at least some degree. However, 8 states ban private insurance plans from covering abortion, again with exceptions. We've talked a lot about the Affordable Care Act over the course of this semester, and as we've seen, the Affordable Care Act seems to have an impact on everything, from information technology to long-term care. We kind of can't talk about anything without talking about it. So here's a couple of facts about the Affordable Care Act and contraception and abortion. The Affordable Care Act maintains the Hyde Amendment, barring Medicaid coverage for most abortions. Many of you might remember back in 2010, the ACA's coverage of abortion, its treatment of abortion, was one of the things at the very end that folks thought might kill the bill. And so there was a compromise made. And this bars the use of federal funds for abortion coverage, except in limited cases. And the ACA requires insurance companies operating on these exchanges that may come to be if the web problems ever get solved. The ACA requires insurance companies offering abortion coverage on the exchange to segregate their funds for abortion and bill separately for abortion coverage. Okay? A little bit of the legal context. In 1965, in Griswold versus Connecticut, the Supreme Court of the United States recognized that a married couple has a right to privacy that encompasses the use of contraception. And prior to that time, there were a few states, including Massachusetts, and Massachusetts actually went on after that, that barred use of contraceptives. In 1973, of course, the Supreme Court decided, one of its most controversial decisions of all time, Roe versus Wade. And Roe versus Wade upheld a woman's right, in consultation with her doctor, to an abortion prior to viability. And it imposed what has come to be known as strict scrutiny on pre-viability abortion regulations. I'm being very rough and loose about this. Then in 1980, the Supreme Court decided that the Hyde Amendment, the lack of coverage for abortion in Medicaid, was not a violation of the right to privacy. So we get this interesting sort of no regulation, no insurance zone. Fast forward a bunch of years, I'm skipping a whole lot of cases here. In 1992, in Planned Parenthood versus Casey, the Supreme Court rejects Roe's version of strict scrutiny and its approach to abortion regulations and adopts instead an undue burden test that really makes it much easier for the states to impose regulations as long as the states do not impose an undue burden on a woman's right to have an abortion. In 2007, in Gonzalez versus Carhart, the Supreme Court went further and upheld Congress's ban on what was known as partial birth abortions. And interestingly, and I think that's going to be discussed later, the language of that opinion seems to say that states can regulate to protect a woman's health and her mental health from the distress she may feel later because she has an abortion. And then in 2012, as we all know, the Supreme Court upheld the ACA's individual mandate as an exercise of Congress's power to tax. Well, the ACA has a contraceptive mandate. Under the ACA, group health plans and health plans must provide preventive services without cost sharing, without co-pays. Based on recommendations from the Institute of Medicine and the National Academy of Science, there's a typo, this is blanking me out. too much in the news, right? The Department of Health and Human Services issued regulations that included contraceptive services as preventive services. They issued exemptions for religious organizations. There was a huge outcry and upheaval, and the administration put in a safe harbor for a year and tried to come up with a compromise eventually. And the compromise was that insurers must offer contraceptive care without copays, free of charge, directly to employees of employers that didn't want to cover it. So if the employer doesn't want to provide contraceptive coverage, the insurer would provide it. And the theory was that contraceptive coverage saves the insurer money, so it wouldn't cost anything. So you can kind of create this separate little shadow plan. The problem was and is that fix doesn't work for the large number of employers who self-insure, who don't purchase insurance from insurance companies like Aetna or Blue Cross, but by themselves actually cover the risk of their employees' health on their own. And in that case, those employers, many of which ardently oppose the contraceptive mandate, have been challenging this mandate. And right now there have been over 40 cases filed across the country challenging the contraceptive mandate as a violation of the employer's religious liberty. These cases are brought under something called the Religious Freedom Restoration Act. The Court of Appeals, the federal courts of appeals, are divided over these cases. They're divided first over whether secular corporations, for example, one of the best-known cases now is the Hobby Lobby, which whether a company like Hobby Lobby can bring claims under the Religious Freedom Restoration Act, and whether the contraceptive mandate imposes a substantial burden on the free exercise of religion. There are 3 cases currently before the Supreme Court, and it is very likely that they will be decided this term, in which case we may have the question of an ACA mandate back before the Supreme Court before the year is out. So stay tuned. These decisions may not have quite as much an impact on the ACA as a whole as the individual mandate case that was before the court 2 years ago, and we can discuss this later, they nevertheless may have very significant ramifications for the idea that employers need to provide an array of services that the government rather than the employer predetermines. And so with that introduction, I'm really pleased to welcome Rebecca Hart.
Good evening, everybody. I'm really excited to be here and wanted to thank Wendy and Tim and Aziza for inviting me. I didn't even know that this lecture series existed, so I think I will be in the classroom coming soon. So I just wanted to start off by telling you a little bit about the nonprofit that I work for, because I think it helps sort of understand my orientation to abortion restrictions, which is what I'll be focusing my talk on. So I work at an organization called Provide. It's based here in Cambridge. And the mission of Provide is to expand access to safe abortion for women across the United States. And so what Provide does is that it looks for the gaps in abortion access that no one else is really addressing. And we go into states, we work with local partners on locally driven mandates, and we work very hard to expand access to abortion in the hardest states. So while I'm trained as an attorney, Aziza and I actually went to law school together, I do fundamentally believe that restrictions on abortion are an infringement on a woman's constitutional right to privacy, but I don't work in that arena. I focus on how to increase access for women. And I'm really, I really fundamentally view restrictions as attempts to decrease access, and I work with teams that are really trying to increase access even though restrictions exist and continue to decrease access. So tonight I'm going to talk a little bit about the legal framework that allows for the regulation of abortion. I'm going to dive into the types of regulations that we see across the states. I'll talk to you about the 2013 legislative session. I'll talk a little bit about Massachusetts law, and then I'm going to really talk about the impact that these restrictions have on access to abortion. So, as we just heard, Roe v. Wade, as you know, decriminalized abortion and has really been the constitutional framework under which abortion was made safe, legal, and accessible, starting in 1973. But since Roe legalized abortion, we've really seen a campaign from state lawmakers for the most part, but a little bit federal lawmakers as well, to try to chip away at Roe, chip away at the fundamental right to privacy. So where Roe found a constitutional right to privacy and created a very clear trimester framework for assessing the constitutionality of restrictions on abortion, state lawmakers have looked for ways to try to chip away at that right. And so what the Supreme Court did in Roe is that it explained that during the first trimester, the decision to obtain an abortion is left solely to the pregnant woman and her physician. The state only had the right to intervene in that decision, and that is to say, prior to fetal viability, only to protect the health of the pregnant woman. And the Supreme Court said in Roe that the state could regulate the procedure after viability so long as there was an exception to preserve maternal health. 20 years later, in Planned Parenthood v. Casey, the Supreme Court heard a case that challenged a spousal notification law in Pennsylvania. So that law said that a woman couldn't get an abortion unless her spouse was notified. It also was a challenge to a mandatory 24-hour waiting period before a woman got an abortion, a challenge to parental consent requirements, and a challenge to informed consent requirements. I'll dive into those a little bit later, to the meat of what those requirements are. But the Casey court really affirmed, fortunately, the central holding of Roe that there is a fundamental right to privacy and that a woman has a right to an abortion. But it went farther. It said that as with any medical procedure, a state may enact regulations to further the health or safety of the woman seeking an abortion. So it struck down the spousal notification provision, but it upheld the mandatory 24-hour waiting period, the parental parental consent requirements, and the informed consent requirements. And it created this new test that's called the undue burden test. And that test says that legal restrictions violate the due process clause if they have the purpose or effect of imposing an undue burden on women seeking an abortion. I don't really know what an undue burden is, and unfortunately a lot of litigators who are much smarter than I am also don't really know what an undue burden is. So what happened was the court created a test that is very, very difficult to understand and difficult to use to effectively challenge laws that infringe on a woman's right to choose. So the Casey court, while upholding the central holding in Roe, really opened the floodgates for state legislatures. It was a sign that there was a new test, that the strict scrutiny test that Wendy talked about a little earlier had been supplemented, and that now it was much more difficult to overturn a restriction. And I'm bashing Casey a lot because it's a difficult decision if you work in this field, but I do think it's important to note that the litigators who brought the case in the early 90s really thought that it was possible that Roe was going to be overturned. And so the decision in Casey was in part a very big victory because the central holding of Roe was upheld, but it just created so much confusion that we were left with quite a bit of uncertainty. So for those of you who are interested in learning more about Casey, I would really strongly recommend reading the book Becoming Justice Blackmun, which is just an absolutely wonderful biography of Justice Harry Blackmun, who wrote Roe and also wrote one of the decisions in Casey, and it explains what happened behind the scenes at the court and how much Roe versus Wade really was likely to be overturned in 1992, and what a sort of why Casey is important but still difficult for advocates. So, state legislatures have really watched developments in the judiciary, and they have figured out that that advocates don't understand, or I should say that's not fair. I should say that courts don't always apply the undue burden test the same way, and so there is little reason for states not to try to test and figure out what is an undue burden and what isn't an undue burden, and what laws can survive in order to try to decrease access and restrict a woman's ability to get an abortion, and what won't. And so I'm just going to give you one example. We can talk in the questions more if you want to, but I want to give you one example of a case that where the Eighth Circuit Court, so a court sitting in South Dakota, found that using the undue burden standard and actually going against the weight of scientific evidence, that a South Dakota informed consent law that mandated that physicians tell patients prior to obtaining their abortion that an abortion increases the risk of suicidal ideation and suicide, that was not an undue burden, that it did not create any substantial obstacle for women seeking to get abortion care. So I'm just going to give you an overview of the kinds of regulations that we see at the state level. The first are, and also I want to put in a plug for the Guttmacher Institute. They have extensive resources that can help you understand state restrictions if you're interested in them. So the first is mandatory waiting periods, and I think we've heard a lot about mandatory waiting periods recently in the news coming out of Texas. But these are waiting periods that say that a woman must wait at least 24 hours between scheduling and receiving her abortion. In some cases, you have to make 2 trips to the clinic. So you make trip 1, 24 hours later, you make trip 2, and you're able to get the abortion. There are states where it's 48 hours, and there is a state where it's 72 hours. There are also medically inaccurate counseling requirements, so those include the one in South Dakota that I just told you about. Another is there's a popular refrain that getting an abortion increases the risk of breast cancer, even though that has been disproven by the weight of medical authority. But there are counseling requirements that mandate that you have to say, that you as a clinician have to say to your patient that if you get an abortion, it could increase your risk of breast cancer. There are mandatory ultrasound requirements across the nation. You probably heard a lot about them in Virginia last year. Ultrasounds in the first trimester are not required. Some clinicians do it, some clinicians don't. It's not a Planned Parenthood and the National Abortion Federation don't require that clinicians do ultrasounds before a first trimester abortion. So it really is interfering with the healthcare decisions of a clinician and his or her patient by mandating that they have to do an ultrasound. There are laws that require teens under the age of 18 to either notify their parents or obtain parental consent to get an abortion. There are they also can get consent from a guardian if they don't reside with their parents, and if the teen feels that she can't go to her parent to obtain consent, the Supreme Court held that we could do something called a judicial bypass, which is where the teen goes to court, goes before a judge, and the judge says that she is emotionally mature enough to make the decision to obtain an abortion. Obviously, parental notice and consent laws further delay abortion care, so when you're in a state that has a mandatory waiting period and then you have to get parental consent or notify your parent, you're just delaying a woman's access or a teen's access to basic health care. There's something called TRAP laws, which are targeted regulation of abortion provider laws. And I just want to read the definition that a professor at CUNY Law School came up with for trap laws, because I can't say it better than she did. Trap laws are generally defined as laws that single out physicians' offices and outpatient clinics where abortions are performed and subject them to wide-ranging medical, administrative, and facility requirements that are not imposed on comparable facilities. So those are things like making sure that the hallway in an abortion provider's office is wide enough so that gurneys can go through it when sometimes those providers are providing medication abortion, which is the abortion that you can get using 2 different types of pills. And so that's the kind of requirement that you would expect to see in a hospital setting, not in a setting where you're getting outpatient abortion treatment. Another facet of trap laws are something called mandatory hospital admitting privileges for abortion providers. So this says that if the provider is not able to get admitting privileges in a hospital within a certain radius of the clinic, so I think most recently it's been 30 to 35 miles, then they are not allowed to provide abortion care in the state. That this is a way of driving providers out of practice, because frequently hospitals will not give providers admitting privileges if the hospital knows that they are providing abortion care. We've seen gestational limits on abortion. One of the most common, I think there's between 15 and 18 states in the country that have done this so far, that is limiting abortion up to 20 weeks, or so that you cannot receive abortion care in the state after 20 weeks gestation. There are some states that are trying to do that sooner. I'll get to that when I talk about what's happening in the 2013 legislative session. But the limits on the gestational limits on abortion very clearly go against Roe's holding that the state can't interfere before fetal viability. So they're definitely an attempt to, if they were to be challenged, to nudge the Supreme Court in a more restrictive direction. Fetal personhood laws, I think, are actually particularly interesting. They would outlaw abortion wholesale by defining the fetus as a person from the moment of conception. So that's before implantation of the egg in the of the fertilized egg in the uterine lining, and by defining the fetus as a person, you would automatically subject the fetus to a host of laws that the fetus is not subject to right now, and it would wholesale outlaw abortion. Personhood laws also, I think a really interesting thing about them is if you have a fertilized egg that you're storing somewhere, for example, if you're doing some kind of fertility treatments and you have fertilized eggs and you're storing them, that fertilized egg could be considered a person under the law, so you might be able to get a tax deduction for that egg as a dependent person that you have custody of. I don't, there are no fetal personhood laws yet in the country, but I think it's a really interesting sort of thought experiment to think of how expansively the definition of person is and how much impact that could have in the U.S. The next thing that we see a lot are refusal clauses for individuals and sometimes for entire healthcare facilities to opt out of providing, assisting in abortion care, or even providing counseling to women who are seeking information about abortion. You see that often not always, but often in public hospitals. States make laws about that public hospitals can refuse, and physicians who are actually any healthcare provider in a hospital can refuse. And then finally, public funding bans on abortion. So the federal government obviously enacts the Hyde Amendment every year, which denies Medicaid funds to low-income women for elective abortion. And states frequently do the same thing. So they use their state Medicaid dollars to also enact bans. There are 17 states that do not have public funding bans, and 34, at least by my most recent count, that do. So 2011, as you probably know if you watch the news, was the high watermark for abortion restrictions. There were 92 restrictions on abortions enacted, and I think there were almost 1,000 laws proposed at the state legislative level. In 2012, it went down a little bit to 43 restrictions. And I don't know the total number yet for 2013, but 6 months in, there were already 43 restrictions. So to talk about what happened this year. North Dakota passed a law that would ban abortion after 6 weeks gestation. So as many of you probably know, most women don't know that they're pregnant at 6 weeks gestation. So it would be a really sweeping restriction that would impact a tremendous number of women in North Dakota. That law is currently being challenged. Arkansas enacted a similar ban, but at 12 weeks, and that law is also being challenged. Arkansas, North Dakota, and Texas also did a 22-week ban. Well, so that's 22 weeks since your last menstrual period, or 20 weeks post-fertilization. I know that advocates have been really reluctant to challenge those 20-week bans because they're afraid that the Supreme Court could rule against pro-choice interests, and that would create bad law going forward, and I think we'd see 20-week bans across the country. In Kansas, North Carolina, and North Dakota passed bans on sex-selective abortions. So those are abortions that are occurring based on the gender of the fetus. There is very, 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 very limited research. I believe there are 3 published studies that state that in certain communities in the U.S. there are sex-selective abortions occurring. But there is not conclusive evidence right now that it's happening, and obviously that I think that the conversation we could spend a whole evening talking about bans on sex-selective abortion. But I personally believe that it's a red herring to try to just prevent women from accessing abortion care under the guise of using their ethnic origin as a reason to prevent them from obtaining care. And then North Dakota also passed a law that would ban abortion for fetal impairment of any kind. So we often hear about the reason that women need to have access to abortion care after 20 weeks. One of the major reasons, not the only reason, but one of them is that we find out that the fetus has some kind of very severe fetal anomaly, sometimes not compatible with life, and women seek abortion care when they learn that news. Sometimes they do, sometimes they don't. It is absolutely up to the woman and her partner to make the decision that's right for them, but I think that should be an option if that's the right course for her and her family. But the North Dakota law wouldn't give women the option to make that choice for themselves. We also saw a tremendous number of new trap laws throughout the U.S., and these included increased clinic regulations. They included the hospital admitting privileges that I talked about before, so providers aren't able to get admitting privileges at hospitals. And they include transfer agreement prohibitions, which says that public hospitals are prohibited from making transfer agreements with abortion providers in the event that there's some kind of complication and the woman needs to go to the hospital. So Alabama, Indiana, North Carolina, North Dakota, Ohio, Texas, Virginia, and Wisconsin passed trap laws this year. The trap laws in Texas are currently being challenged. The ones in Virginia have gone into effect, and the ones in North Carolina are about to result in the closure of, I believe, at least 5 clinics. Indiana and Texas passed mandatory ultrasound laws. Texas mandated that you have to make 2 trips into the clinic for medication abortion. Right now, if you're seeking medication abortion, in most of the rest of the country, you go into your provider. He or she gives you the 2 medications that you need to take, one after the other, in order to induce abortion. And then you take one at the clinic, and then you take the other at home. I think it's 48 hours later. And this would mean that you have to return to the clinic after, I think it's 48 hours has elapsed, in order to get the second medication. One way that medication abortion is distributed, especially to women in rural counties, is through telemedicine. So it's hard for me to wrap my brain around this at first when I saw how it happened, but telemedicine is actually quite common, a very common way of providing health care for people in rural America. And a couple of clinics serving large rural populations in Texas and Iowa, they've really been at the forefront of this, developed a system whereby a woman could go into her local provider's office. It's usually a Planned Parenthood, though not always. And she could basically video conference with her provider. So she's sitting in, Abilene, Texas, and her provider is in Austin, Texas, and they have a conversation, and the nurses and the clinicians helping her in Abilene give all of the information necessary to the provider in Austin so that he or she can make the decision about whether or not medication abortion is appropriate. And if they do make the decision that that's the right course of action for her, they press a button. The provider presses a button on their end, which opens a drawer on the other side where the woman actually is, and she is dispensed the medication for abortion. So that has been prohibited in Indiana, Iowa, Louisiana, Mississippi, Missouri, North Carolina, and Texas. Several states have also limited who can dispense medication abortion. So sometimes some states have laws that it's just physicians. Other states have laws that physicians and advanced practice clinicians can do it. And unfortunately, that has also been banned. Alaska, Arkansas, Georgia, Iowa, Maryland, North Carolina, Pennsylvania, South Carolina, and Virginia have done a bevy of things to restrict insurance coverage of abortion. Those things include prohibiting health insurance plans on the state exchanges from selling insurance that would include abortion. It includes public funding bans. It includes bans for the health insurance that state employees receive, so it prevents their insurance from covering abortion care. Kansas enacted new bias counseling requirements that provide women with inaccurate information about what will happen, what could happen to her as a result of the abortion. Ohio has a novel bill, and a lot of people are saying that Ohio is sort of a new testing ground for abortion regulations. It's been called the fetal heartbeat bill, and so not only did Ohio prohibit public hospitals from making transfer agreements with abortion providers, but they also now require clinics to follow a government-mandated script when dealing with patients, and to present them with evidence of, to present them with the ultrasound if they don't have a choice in seeing it, and also to present them with evidence of the fetal heartbeat before performing the abortion, and if they don't do that, they face criminal prosecution. South Dakota passed a mandatory 72-hour waiting period. That waiting period excludes holidays and weekends. So if you call the provider on a Friday, the clock does not run Saturday and Sunday, and if Monday is a federal holiday, that 72-hour clock is not running. So that doesn't kick in again until Tuesday. So it really is delaying women's access to abortion care. So I am not an expert in Massachusetts law by any stretch of the imagination, but I did want to talk a little bit about what happened in Massachusetts, especially because there's some interesting stuff happening with the Massachusetts buffer zone law. So there was no legislation on reproductive rights in Massachusetts in 2013, but there is a current law. There's a buffer zone that establishes a fixed 35-foot zone outside of abortion clinic entrances and driveways that says that protesters cannot enter that zone during normal clinic hours. And I really want to encourage you to go to one of my favorite websites, which is SCOTUS blog, to look up the case McClellan versus Coakley, which is a challenge to this law. I'm not a First Amendment expert, but I'm going to do my best to explain what is happening with this law. So Massachusetts has the 35-foot buffer zone. That law was passed in 2007. From 2000 to 2007, Massachusetts had a 6-foot buffer zone around individuals who were approaching the clinic. And the Supreme Court in the year 2000 heard a case called Colorado v. Hill, which upheld a similar Colorado law, creating that 6-foot barrier. So Massachusetts decided to amend the law in 2007 to create the 35-foot buffer zone. And the state argued that there were real concerns about violence, there were still real concerns about women's access to the clinic, despite the fact that there was this sort of six-foot wall around her. And they said that it was hard to enforce and that public safety was an issue. There are some anti-abortion protesters that challenge the law, and basically they are arguing that it's an infringement on their First Amendment rights. Their argument is that they would like to be able to approach women in a non-violent way, to give them flyers and information about abortion as they are going into the clinic. They are particularly upset that what they perceive their viewpoint is being discriminated against because abortion clinic employees are allowed to be within that 35-foot zone. So they feel that it's viewpoint discrimination that the clinic employees, who are likely advocates of abortion, are able to be in the zone escorting women into the clinic, whereas they have to be outside of the 35-foot zone. I don't know how the court will rule on that, but I don't ever think it's good when the court decides to hear a case on abortion. So we'll see how that turns out. Massachusetts does have a slightly better Medicaid law to help cover abortions for low-income women. So not only can women get coverage in the instance of pregnancy resulting from rape, incest, or when the pregnancy is a danger to the life of the pregnant woman, but also when the abortion is medically necessary. And Massachusetts also has a parental consent law, but we have a very robust judicial bypass system here in Massachusetts. And I know that lots of teens are able to take advantage of that when they don't feel that it's safe to go to their parent or guardian to ask for permission for an abortion. So I know it's actually a little better to see this because it's so big, but I just wanted to sort of give you a view of the number of abortion restrictions by state, because I think it's pretty fascinating to see how different it is in different areas of the country. So this was done in 2012, so it doesn't account for the current legislative session, and it was done by a great organization called Remapping the Debate. And you can see that in 2012, Oklahoma had the most abortion restrictions, and I'm not sure if you guys can read the colors, but I'll just tell you quickly what they are. The brown, which almost every state, I guess about half the states have, are mandatory waiting periods and counseling. The next one is red, which are physician and hospital requirements, so like the admitting privileges that I spoke about before. The dark blue is limitation on insurance coverage. The green is ultrasound requirements. The orange are 20-week bans. The gray are more track laws, targeted regulation of abortion providers. Green is parental involvement of some kind. Pink is not a law, but it's actually designating scarcity of abortion providers. The next green is a limitation on public funding, and the sort of aqua-colored one is a near total abortion ban. So a lot of states have what are called trigger laws. So if Roe v. Wade is overturned, the abortion will instantaneously become illegal in their state. Those laws are currently not enforceable because of Roe, but would become enforceable if Roe was overturned. So I think it's just a really interesting visualization to show where you live matters. It really matters in your ability to access abortion care. So I just want to spend a few minutes really talking about the impact of laws that restrict access, and all of those laws are really designed to decrease access to abortion and prevent women from obtaining abortion care. So I'm just going to talk about Oklahoma a little bit. It's a state that I do a lot of work in. It's also a state that I enjoy visiting. And there are a lot of great people in Oklahoma doing a lot of really exciting work to expand access to abortion. But it is hard. It is very hard to obtain abortion care in Oklahoma. Oklahoma, for those of you who have never been there, is almost 70,000 square miles. It has 6 known abortion providers. Some of those are doctors who work in hospitals, and there are 3 known clinics. It also has 55 crisis pregnancy centers, and crisis pregnancy centers are places that they spring up directly in response to clinics springing up, and they attempt to dissuade. They are places that attempt to dissuade women from obtaining abortion care. So if you go to a crisis pregnancy center, sometimes you'll be told that you can get abortion care there, and they'll delay your abortion and delay until you have passed the gestational limit in the state. Sometimes they will tell you that if you carry the pregnancy to term, they'll help you with adoption, or they'll help you pay for whatever costs are associated with the pregnancy and then caring for the child. They sometimes they'll give you an ultrasound, and they'll show you a picture on the ultrasound screen that is a picture that's not associated with your pregnancy. So it's a picture of a fetus at a different gestational age. I think it's telling when you think about what access is like in Oklahoma, that there are 6 abortion providers, and there are, by my last count, 55 known crisis pregnancy centers. And a lot of the times those crisis pregnancy centers advertise as though they provide abortions, so they're very easy. If you don't know what to look for, it's very easy to go into a crisis pregnancy center thinking that you're going to obtain abortion care. So Oklahoma has a mandatory 24-hour delay, and it has a state-mandated informed consent requirement, so biased counseling requirements. Oklahoma law prohibits private insurers from offering insurance for abortion care on the state exchange. It prohibits public employees from obtaining health insurance through the state that covers abortion care. And it also prohibits Medicaid from covering abortion care, except in the case of rape, incest, or a danger to the life of the pregnant woman. Oklahoma law requires teens under the age of 18 to get parental notice and consent to the abortion 48 hours prior to obtaining the abortion. And when you think about it, it just creates an incredibly high bar for finding abortion care. You've got the mandatory delay, you've got the lack of abortion providers, you've got clinics that are trying to dissuade you from getting an abortion. You've got biased counseling requirements, and if you're a teen, you've got an additional 48-hour delay. So Oklahoma is a really good illustration of why it is so hard to obtain abortion care. And with that, I am going to turn it over to Aziza. Thank you.